Hi, folks. Good afternoon. This is Anthony Enea of Enea, Scanlon, and Sirignano with offices in White Plains and Somers, New York. I hope everybody is doing well and staying safe. And I know it's a difficult time for everybody, but when things get tough, the tough get going, as they say. And New York State has decided to make things a little bit tougher for all of us when it comes to Medicaid eligibility. I can understand the budgetary issues that New York is suffering through. So I see that there is some logic to what they've tried to do, especially when it comes to the Medicaid home care program. But in light of us dealing with this COVID-19 pandemic, this was not something that we needed to deal with now. And but we're going to have to. So that's the way life is. And whatever they tell us to do, we do. And when you're given lemons, make lemonade. So we're going to make some lemonade today, and we're going to try to figure out how to get by this Medicaid home care change in rules, which is significant. So before I tell you what they've done, let me tell you what the law is today and what the law has been vis-a-vis Medicaid home care for the last, I would say, at least 8 to 10 years. So basically, there has been no look back period for Medicaid eligibility with respect to home care applications. What does that mean? That means that if you were applying for Medicaid home care, it was irrelevant as to whether or not you had transferred assets prior to making the application. So whether or not you had put assets in a trust or gifted assets to your children, that would not impact your ability to be eligible for Medicaid home care, which is also known as community Medicaid, because there were no look back provisions. So the look back provisions just were not applying to Medicaid home care. So, which was good, because what would often happen is that an individual and the individual's family would contact us and would say, my mom needs help at home. She's having difficulty walking, dressing, feeding, bathing, toileting, cooking. These are all what's known as the activities of daily living. And that individual, if they were single, what we would recommend is that they take assets out of their name so that they would have less than $15,750 of what's called available resources or the luxury fund. So if a single person came to us and had, let's say, $200,000 or $300,000 of assets, normally what we would recommend is that they take those $200,000 to $300,000 and transfer them to an irrevocable Medicaid asset protection trust. That would drop them below the $15,750 that they're allowed to have, and now they would be resource eligible for Medicaid eligibility purposes. Obviously, would still need to look at their income and have to determine whether or not they would needed to do what's called a pooled community trust in order to protect their income, which is a great vehicle, by the way, that New York has allowed to be used and still allows to be used, even in spite of these new changes. And I'll tell you when the changes are going to be effective in the law, but they're all part of the Governor Cuomo's budget proposal that was enacted last week, I believe on April 3rd, and I'm sure it's been signed into law already. So with respect to the Medicaid home care, there has been no look back period. What if the individual that has been applying for Medicaid was married? What could we do? Well, sometimes what we would do is have the husband and wife both give the assets that they have and move those assets out of their name. The reason we would recommend that would be so that the spouse could avoid doing something called spousal refusal. So if you have a husband and wife, they can move assets to each other without creating any periods of ineligibility for Medicaid. That's what's known as an exempt transfer, an exempt spousal transfer. So husband and wife can always move assets to each other without creating any periods of ineligibility. So hypothetically, if the husband is the one that needed the Medicaid home care, he could move all of his liquid non-IRA assets to his spouse. That spouse then, if she had more than the amounts that are permitted for Medicaid eligibility, and I think the number has been about $120,000, then that spouse, it's actually 128 now, then that spouse would be able to get Medicaid, and the spouse that's receiving all the assets could do something called spousal refusal. He or she could refuse to use his assets and income to support the individual that needs Medicaid. Sounds good, and it has worked very well. The problem is that when a spouse does spousal refusal, the spouse that is doing the spousal refusal is now putting themselves in a position to be sued by Medicaid for the value of the services that they've provided. So, if, for example, I'm getting Medicaid home care and my wife has done spousal refusal to allow me to get Medicaid home care, now what will happen is my spouse can be sued by Medicaid for the value of the services they're providing, what they're paying for the services. So in Westchester County and New York State, especially lower New York, Medicaid has become more aggressive in the last year or so in pursuing spousal refusal cases for Medicaid home care. So one of the ways that we were getting around having to do spousal refusal, which we can still do now until the new law becomes effective, which is October 1, 2020, was having both the husband and wife move assets either to the children outright or to a Medicaid asset protection trust, which is generally a much better vehicle to protect assets. Parents are very leery of giving assets outright to their children because they're concerned about divorce, they're concerned about the children being sued, having creditor claims, etc. So what we would normally do is create the trust and put the assets in the trust and make one of the spouses eligible for the Medicaid home care. Now we have this new budget bill and their recommendations that a lot of them were implemented. And the major one that was implemented is that commencing on October 1st, 2020, there's now going to be a 30-month look-back period for Medicaid eligibility for Medicaid home care. There is still going to be a 5-year, 60-month look-back period for Medicaid nursing home, but now for the first time, we have a 30-month look-back period for Medicaid home care. So what does that mean? Well, that means for any applicant for Medicaid home care, community Medicaid, starting on October 1st, 2020, and going forward, when you go to apply for Medicaid, Medicaid is going to want to see your financial records, copies of all your bank account statements, brokerage account statements, annuities, life insurance, bank accounts. They're going to want to see all of your financial records for the last 30 years. 30 months, excuse me, 30 years, 30 months. And those records, right, are going to have to show whether or not you've made any transfers of assets. Have you made what's called an uncompensated transfer? Have you given away assets as a gift and not received something of equivalent value back? Okay. Now, Medicaid generally looks to see if those transfers or assets are uncompensated. And then the other issue is, are they exempt transfers of assets? What does that mean? Are they exempt? There are some transfers of assets that do not create any periods of ineligibility for Medicaid. What are they? Well, a transfer to your spouse, a transfer to a blind, disabled, or minor child. That does not create any period of ineligibility for Medicaid. Transfer of assets to a special needs trust for a child do not create any periods of ineligibility for Medicaid. You can transfer your house to a caretaker child. If you have a child that's been living with you for at least 2 years and providing care to you and continues to provide care to you, you can transfer your house to that child without creating any ineligibility for Medicaid home care. and or Medicaid nursing home. The other transfer is the transfer of the house to a sibling with an equity interest. So if you have a house that your brother or sister has an equity interest in, and that doesn't necessarily mean they are actually an owner of the house. They could be someone that pays the bills for the house, has help with the maintenance and expenses of the house. They could be considered to have an equity interest. And again, if they've been living in the house with you for a period, I believe, of 2 years, if you transfer your house to them, that would be an exempt transfer. So other than these exempt transfers, every other transfer that you make is a non-exempt transfer that creates the look-back period for Medicaid home care and Medicaid nursing home. So come October 1st, if you're going to be applying for Medicaid home care, you got to show Medicaid 30 months of financial records with copies of all checks, deposits, and withdrawals. In Westchester, the rule has been $3,000 or more. If you have made transfers during that 30-month look-back period, then what happens is you create a period of ineligibility for Medicaid that's determined based on the dollar value that you gave away and is divided by the divisor that's used by the county where you reside. The county of Westchester, our divisor is close to $13,000 a month. I think it's $12,844 per month. So that's how they would calculate the period of ineligibility. So if you gave away $120,000, take that and divide that by $13,000 per month, and that would tell you the period of ineligibility. Okay? So this is a big change. It's a monumental change for purposes of seniors that need to access the Medicaid home care program. It's significant. And this change becomes effective on October 1st and going forward. What does it mean for seniors today? We're now in the middle of April. We're on April 8th. Unfortunately, a lot of us are at home right now, but it really means that between now and October 1st, seniors have a window of opportunity to start protecting their assets. And when I say start protecting their assets, I mean creating the look-back period. In order to protect assets, you have to create the look-back period. And the look-back period is created by when you make an outright transfer of assets that is not an exempt transfer. So if you take your monies, your savings, your non-IRA savings, and you transfer them into an irrevocable trust, and you do that now, or you take your house and you transfer that to an irrevocable trust, and you're making these transfers before October 1st, 2020, and then you need Medicaid after October 1st, 2020, the transfers that you're making now until October 1st will not create the look-back period for Medicaid home care. They will create the look-back period for nursing home Medicaid because they always have created a look-back period, but they won't create the look-back period for Medicaid home care. That is very important because today, unlike in the past, the program that most seniors want to become eligible for is Medicaid home care. That is the most common application that we're filing today. I would say that when we look at all the Medicaid applications that we file in the offices at Enea, Scanlon, and Sirignano, we probably file over 200, 250 Medicaid applications a year. I would say at least 80 to 85% are Medicaid home care applications. Why? Well, seniors want to stay home. Aging at home, aging in place has become a very popular concept for seniors. They like their houses, they're comfortable in their houses, and they don't want to leave. The best example I always use is my mom and dad. They've been living in White Plains for the last 60 years approximately. They have a house, and the only way I'm going to get my dad out of that house is feet first. We've talked about downsizing a million times, and he's not interested. He loves his garden. He loves his yard. Starting the month of March, he goes outside and he starts working in the yard, even though he's 88 years old and something that he loves to do, and getting him out of that house is impossible. It's not going to happen. We've had millions of conversations. We've gone to see houses. We've gone to see condominiums, and it's just not going to happen. So protecting your assets, starting that clock running now before October 1st is critical, because if you wait until October 1st and if you're going to need Medicaid home care benefits in the next 30 months after that, if you give away assets, you're going to disqualify yourself if you're a single person. This is really harsh for a person that's not married, a single person. If the person is married, well, then there are other options. Obviously, we could transfer assets from the spouse that needs the Medicaid home care to the spouse that doesn't need Medicaid home care. We can still protect the income of the spouse that's applying for Medicaid home care by doing the pooled community trust, but we're running the risk now that Medicaid can pursue a claim against the refusing spouse for the value of the services they provide. Now, fortunately, when it comes to Medicaid home care is a system under managed long-term care in New York State. That's what they call a capitated system, which basically means that no matter how many hours are being provided to the individual needing home care, Medicaid is only giving the provider, the agency, the home care agency, a fixed amount. So whether you're getting 24 hours a day care or you're getting 12 hours a day care or 6 or 4, the home care provider is only getting paid a certain dollar amount, a specific amount, irrespective of how many hours you're getting provided. Okay? Now, there are talks now of changes on how they're going to be looking at the individuals and the applicants vis-a-vis do they need care? Is it safer for them to be in a facility than to be at home? And we'll talk about that in a little bit. So the option of doing spousal refusal is still available for Medicaid home care applicants if they have a surviving spouse. So it's a very good system. It's still a good system. Fortunately, they did not get rid of the spousal refusal provisions, and they left the community spouse resource allowance amounts pretty much the same. There really is no change there. So from a Medicaid home care perspective, we can still access the system, especially for married individuals. But for single individuals, it's going to be very important. The next 5-6 months are going to be critical for those elderly seniors who think they're going to be needing home care services, that they really get their act together and start moving assets out of their name so that they can be exempt from this 30-month look-back period in the event they need home care Medicaid after October 1st, 2020. Okay, so that is the big change. I mean, for many years, we were able to move assets from one person to another, from a parent to a child, and get Medicaid home care benefits for that parent. Those individuals that did that and are in the system, they're all grandfathered. There's no concerns or worries about them. They're still going to get the benefits as they have been getting in the past. But for individuals going forward, there's definitely a change in the rules. And that change is quite dramatic. I mean, the ability to just move assets from one person to another after October 1st and get Medicaid home care benefits is going to be significantly reduced. Okay? So what are the other changes that were made? Well, the other changes really have to do with what's called the CDPAP program and the Personal Care Services program. These are separate programs. They're part of Medicaid, obviously, but they're the programs where, for example, you can hire a family member to provide care to you in your home, to be the home care provider. You can't hire your spouse, but you can hire a child, a sibling, a niece or nephew, or even a stranger, someone that you want to hire. And the way the CDPAP program has worked and this personal care services program has worked is that, in essence, that when you are the individual hiring, you're responsible as the individual to make the decisions, right? Hiring, firing, training, and also backup. So that is a program that works well in, for example, rural areas where it's difficult for home care providers to go. For example, you live in Pound Ridge, you live in North Salem. It's difficult for a home care provider, unless they have a car, to be able to get to your house. So many times, a lot of our clients were using the CDPAP program, which is basically the acronym for the Consumer Directed Personal Assistance Program. And basically, what they could do is that they could hire an individual. They would be responsible for paying that individual's hours, training that individual, and having backup. And that's really where the big drawback with the CDPAC program is that the drawback is that if you need backup, you can't go to Medicaid and say, "Hi, Medicaid, my aide did not show up today. I want you to send somebody else." You can't do that. You have to have backup for the aid in the CDPAP program. So that is a big distinction. Now, what they've done also in the CDPAP program, they've also tightened the eligibility requirements and tightened the activities of daily living that are required for that individual. So in the past, right, you still had to have the need for assistance with activities of daily living. Now they basically have changed it so that the individual that's applying for CDPAP or the PCS program must need physical maneuvering with more than 2 activities of daily living. So the activities of daily living are walking, dressing, feeding, bathing, toileting, and obviously cooking. Now, with respect to the CDPAP and the personal care program, with those activities of daily living, with at least 2 of those activities of daily living, the individual has to need assistance with maneuvering. Additionally, if the individual has dementia or Alzheimer's, they're required to need at least supervision with more than 1 activity of daily living. What have they done? They've made it a little harder for an individual to access the program based on their physical attributes and their physical needs. So again, this is another change in the law that is going to make it a little bit more difficult for individuals that are applying for this program. The other big change that they made is that now, when you're applying for the program after October 1st, you can no longer use a report and a statement by your own treating physician. Now you have to get an independent physician to make the recommendation, and that independent physician is selected by the New York State Department of Health. So they're going to have doctors to whom you may have to utilize to make these independent evaluations as to the requirements for the CDPAP program and the personal care services program. And they're also appointing the Department of Health to have an independent assessor to review the recommendations of the physician from the Department of Health. Again, a more tightening, a more stringent requirement for purposes of these 2 programs, the CDPAP and the PCS program. I think this is all in keeping with the budgetary restraints that New York is facing. Obviously, the COVID-19 pandemic has made things even worse. I would not be surprised that in years to come that we see an even greater tightening of the Medicaid program. But what does it mean? It still means what it's meant for the last 20 some odd years. Seniors need to be proactive. You have to go out and protect your assets. Unless you're independently wealthy, unless you're someone that has millions of dollars of assets and can afford to privately pay for home care or can afford to privately pay for nursing home care, you need to be able to take the steps now to shelter and protect your assets so that you can become eligible for either the Medicaid Home Care program or the Medicaid Nursing Home program. And unfortunately, with this law going into effect on October 1st, especially if you see yourself needing either Medicaid Home Care or Medicaid Nursing Home in the near future, and your families are concerned about that happening, you really have to go out and make the moves and transfer assets as soon as possible. Okay? The other big change that's coming about with respect to the Medicaid program in terms of the CDPAP is the revision that they're making with respect to individuals needing more than 12 hours of care. This is something that's another, I think, significant change. The new law authorizes the Department of Health to adopt standards by emergency regulations for extra review of individuals, quote, whose need for such services exceeds a specified level to be determined by the Department of Health. What does this mean? This means that if you're a person that is getting 12 hours of care or more, the Department of Health is going to be able to come out and evaluate to determine whether you're really capable of living in the community safely. Or are you better off living in a facility because of this level of care that you need, these 12 hours or more, that you're actually not able to live safely in your house? This is a very tricky area for the Department of Health because there is a Supreme Court decision in a case called Matter of Olmstead that raises a lot of requirements with respect to persons living at home. And I think that this is one of those gray areas where people who find themselves perhaps having the Department of Health Medicaid coming out and cutting back their hours are going to have to challenge that determination. And that's something that we do in our offices. We handle fair hearings when there is a determination about hours and an amount of hours of care that an individual needs. So this is going to be one of those tricky areas, especially for those individuals that are getting 12, 24 hours of care, where we may see Medicaid coming out and doing these evaluations to try to reduce the number of hours that these individuals are getting. Again, I think this is perhaps one of the more important changes that's kind of like hidden within this new budget proposal and these new regulations and rules. But, the bottom line is that seniors need to be proactive. You have to go out and make the decision to protect your assets. And for many, many years, almost 30 years now, I've been using what's called a Medicaid Asset Protection Trust, which is a fantastic vehicle for seniors to protect their assets. My mom and dad have it, and I've probably done thousands and thousands of these trusts over the last 30 years. All right, let's look at some questions. There's some questions I have here. Does the 30-month look back apply to only new applicants, or will it be also for renewals of Medicaid? It's only for applicants that are filing on or after October 1st, 2020. It does not apply retroactively for other individuals. So if you're applying for Medicaid, community Medicaid, home care Medicaid, on or after October 1st, then this 30-month look-back period will apply. Let's see, another question. Can you hire someone who is an agent under the Medicaid applicant's power of attorney? That's an interesting question. I don't see any reason why you couldn't hire somebody that's your agent under the power of attorney, as long as they're not your spouse. I don't see that as being problematic. So yeah, I think that you can hire anybody other than your spouse, a family member, non-family member, and I don't see why an agent under a power of attorney would be excluded. I don't see that. Will this affect pooled income trust? No, I think the pooled income trust is status quo. There's no changes to it. It's going to continue to be effective, a great vehicle to allow seniors to stay at home and basically keep virtually all of their income. So it's a fantastic vehicle. I think seniors are going to be able to continue to use it when they're doing Medicaid applications. For those of you who are not familiar with it, the way it works is as follows. So, from a Medicaid perspective, every home care recipient applicant is allowed to have $879 of income. So if for example, you have $2,000 a month of income, what happens is that figure, the 879, you get to keep first, and then the difference has to go to a pooled community trust. So that money goes to the pooled community trust, which is run by a charity. It's administered by a charity. The charity is going to charge an administrative fee. Generally, the administrative fee is about $200 a month. It can be less depending on the amount of the surplus income. And then the balance after that administrative fee is deducted, that balance of income is now available to pay the bills of the individual applying for the home care. It could be applied to food, clothing, taxes, insurance, cable, car lease insurance, all of your expenses, including home care, with the exception of alcohol, tobacco, and firearms. You can't use the surplus income for alcohol, tobacco, and firearms. So it's been a great tool to allow seniors to stay at home, age in place, and still not lose their income. Okay, let's see. Okay, let's see. Oh, someone has just clarified that CDPAP does not allow a designated representative agent under the power of attorney to act as the home attendant. Well, that's surprising. I don't see the logic behind that, because what if your agent is not even a family member? But it's good to know that. So if you're an agent under the power of attorney, you cannot you cannot be hired under the CDPAP program. Okay. I don't see any other questions. Thank you. I hope you found the program informative today. And please stay safe, stay healthy, stay inside, and we'll keep plugging along. And we'll be providing you more information on Facebook and more programs forward for you going forward. If you have any questions, please feel free to email them to me at a.enea at AOL. A.enea at esslawfirm.com. And you can always call us at the office, 914-948-1500. Everybody in the office is working remotely. All the attorneys, the partners are all working remotely. And we are available to do teleconferences with you on Zoom, Skype. So if you're interested in a consultation, please reach out to us. And as I've said for the last 35 years, be proactive. Plan to protect your assets. Get assets out of your name. So, and again, when you're using the Irrevocable Medicaid Asset Protection Trust, there is very little change in your lifestyle when you've put your house and some of your savings in the Medicaid trust. Have a great afternoon, and it was a pleasure speaking to you again. Thank you. Bye-bye.